Hi, I'm Ali Jackson-Jolley. I'm here with Dr. Mark Goldfeder, who is a constitutional scholar. He is also the director of the National Jewish Advocacy Center. Mark, welcome.
Thank you. It's great to be here. Thank you for having me.
Yeah, and so I brought you here to talk about the situation that we're watching play out, in which there is growing anti-Semitic sentiment on college universities, and most recently, three NYU students are suing their university for not doing a better job at protecting them. Largely, university presidents are staying relatively muted on the topic, and are either outright pointing to the need to protect freedom of speech or alluding to that need to protect it. You said that those presidents, those university leaders, are either misunderstanding or misinterpreting freedom of speech and how it should be protected. Can you explain that to me?
Sure. I'll start by saying that it's absolutely true that freedom of speech and even offensive and hateful speech should be protected. The really important thing to consider is that there are limits to what constitutes speech, and there are rules for when that speech crosses over into actionable unlawful conduct. So, for example, the First Amendment does not protect trespassing or vandalism or harassment or assault or the destruction of property. It doesn't protect speech that's not meant to inform or persuade, but rather to disrupt lawful endeavors like going to the library or eating in the kosher dining hall. It doesn't protect someone who's making true threats. The Supreme Court in Virginia v. Black said it's statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. It doesn't protect intimidation. Just a few months ago in Countman versus Colorado, the Supreme Court clarified that the intent standard for true threats is not that the person speaking actually intends to threaten the victim. It's that a person who consciously disregards a substantial risk that their communications would be viewed as threatening violence. And all of the above have occurred on American college campuses in recent weeks, if not days. But I would say that the problem here is actually even more acute, and this is what I meant by misapplying the First Amendment. There's no First Amendment protection for speech that involves incitement, which the court in Brandenburg versus Ohio explained that, speech directed to inciting or producing imminent lawless action. And that's a very, very high standard. But the truth is that even a public university is not a public street, and that is not the standard that they should be using on campuses. Brandenburg is the wrong standard for schools to be using, and university presidents and general counsels should correct that misunderstanding, because in Tinker versus Des Moines, the Supreme Court found that the Constitution does allow for schools in particular to regulate speech that will, and I'm quoting here, materially and substantially interfere with the requirements of appropriate discipline in the operation of that school, or if it would invade the rights of others. That is the standard that these schools should be vigilantly enforcing. Now, of course, private colleges and universities are completely different. They can restrict certain speech without triggering any constitutional issues. But again, even a public university, the rules for what speech is allowed are different than what courts are saying. And the Supreme Court in Healy versus James cited the Tinker standard to hold that university officials do not have to tolerate student activities that breach reasonable campus rules or interrupt the educational process or interfere with other students' rights to receive an education. And under Title VI, that right includes the right to receive that education in a harassment-free environment.
So I heard you say public schools and universities are held by a slightly different standard than private institutions. So NYU being a private institution, do you think that case that I mentioned, in which three university students sued their college, which is New York University, for not doing a better job at protecting them against anti-Semitism. What do you think of that case? Is that going to be a harder case for them to prove? Is it less open and shut because it is a public university, a private university?
If I could just take a step back and sort of explain the background for how that case, I think, it's really important, because so Title VI of the Federal Civil Rights Act, if anyone doesn't have the background on that, it requires schools to ensure that their programs and activities are free from harassment, intimidation, and discrimination on the basis of race, color, and national origin. And very importantly, you'll notice It doesn't give the Department of Civil Rights jurisdiction to investigate religious bias, including Judaism. So until 2004, the Office of Civil Rights really didn't investigate anti-Semitism cases. And in 2004, the OCR, the Office of Civil Rights, issued a series of policy statements announcing that henceforth they would investigate anti-Semitism complaints to the extent that they implicated ethnic or ancestral bias. Because the truth is, most of the discrimination we're seeing has nothing to do with someone does or does not light Shabbat candles every Friday night. It has to do with a real or perceived connection to, for example, the state of Israel. That policy announcement is nowadays known as the Marcus Doctrine, after Ken Marcus, who is the director of the Brandeis Center, where I'm also a senior counsel. And that idea, by the way, has been confirmed in both Title VI and Title VII cases in court. And so schools should be really putting that into practice as well. But it left a small hole in discrimination law, because even though anti-Semitism now fell under Title VI, it wasn't always clear what anti-Semitism actually meant. Without a definition, it's very hard to fight something. So in 2019, with Executive Order 13899, the federal government adopted the International Holocaust Remembrance Alliance definition, the gold standard international definition of anti-Semitism, to be used to determine the intent in those kinds of cases. And schools like NYU, for some reason, have been hesitant to do that, have been hesitant to actually, every year they sign an affirmation saying that they're going to abide by Title VI, including all of the rules and regulations. And 3 times this year already, in January, in May, and just again on November 7th, the Department of Education has released statements saying when you investigate anti-Semitism, among the resources you need to look at are the International Holocaust Remembrance Alliance definition. So this case, a lot of it focuses on really applying Title VI as it should be applied. So it's groundbreaking in the sense that it'll hopefully be the first time that a federal court actually holds this standard to be enforceable.
Oh, that's interesting. And so let me ask you, when you think about freedom of speech, let me ask you some other things that we've seen related to colleges and students. So the doxing campaigns, in which some trucks have been, publishing the names of students. In this case, students that were pro-Palestine or pro the Palestinian territories or anti-Israel, either way. Taking students' names and putting them on trucks and then driving them around. So are those instances of doxing? Do you think, is that freedom of speech protected, or is it not, in your opinion?
Well, I'll take a step back, because I do believe that those trucks weren't meant in any way, and Bill Ackman, who did it, is actually famously pro a two-state solution and pro-Palestine. I think they were meant to be people who were pro-Hamas and who had signed a statement that was seen as legitimately pro-Hamas. And I think I'll break it down to a couple of things. Number one, in general, I do think it is good for people to be held accountable for their public statements. Doxing usually is the spread of, I believe, there are a number of different doxing laws, many of which I do believe are unconstitutional restrictions, but doxing is disclosing sort of private information that you obtained in unlawful means. But if you sign a public statement, I think you have to be able to be held accountable for signing that statement. And again, I believe in that particular case, any student who wanted to say that they didn't sign it or wanted to retract it was immediately taken off. So I think that's an important consideration generally. So from a legal perspective, I don't think there's anything wrong with it. Question of policy, again, I think that it's accountability is what we're lacking in a lot of these situations. What Jewish students are asking for is for universities to hold people accountable for what they're saying, what they're doing, and to the extent the universities aren't doing it, those doxing trucks are meant to say, look, you want to make those statements, that's fine, but they do have real world consequences, and that companies might not want to hire you.
Yeah. So let me ask you, do you think that you mentioned in these cases, and also just in your conversations with students, that they are asking their universities to make sure they're keeping people accountable, keeping that college community accountable for the things that they're saying and doing. Do you believe that students and faculty and teachers should be held accountable in the same way? Do we hold students accountable to the same degree that we hold teachers and college administrators accountable for the things that they're saying or doing?
I think it very much depends on the context. In general, students, for example, at a K through 12, less accountable. At a college university where they're adults, pretty much accountable. The difference with the faculty is whether or not they're speaking with the imprimatur of the university. So, for example, if they're speaking in an official capacity in the classroom, the school has to move a lot quicker to shut that kind of speech down if it's offensive and hateful in a way that violates school policies. Whereas students, again, with reasonable time, place, and manner restrictions, can say all kinds of incredibly hateful things, and the university can't stop it. Now, I do believe that they could and should use their own speech, right? Counter speech is an incredibly effective way of doing this to shut it down, but it's different, for example, if it occurs in a classroom. With the imprimatur of the university, the school has a much more affirmative obligation to step in and to actually regulate that speech.
Yeah, and so how about, can I ask you to zoom out for a little bit? One thing I've been thinking about is that anti-Semitism has been on the rise beyond college campuses, right? We've known this. Forbes, we've covered it. This has been even prior to the Hamas attack that our country has been really facing a rise in anti-Semitism. We also know that there has been a rise in hate language hard stop against all groups, or I should say against many groups. Arguably, that began in the 2016 presidential election, in which language began to be used in a way that was pejorative and derogatory against different identities or groups or individuals based on identity. We have since seen that from senators and members of Congress on both sides of the table. I'm very agnostic about this. It's both sides. Us focusing so closely on universities and what's going on, are we missing the bigger picture, the need to address some, redefine or readdress the way that we should be using language in a pejorative manner against people based on their identity?
Sure. I don't think it started in 2016. 2016 might have given more open leeway for people to be, but I think it more revealed an ugly side of what's been going on for many years. And yes, I think the reason to focus on universities, and really, honestly, by the time you get to university, it's too late. So I think we should be focusing a lot more on K through 12, to be honest with you, because look, from a practical perspective, study after study after study has confirmed that hateful rhetoric of any kind leads almost directly to conduct, and that it is an absolutely horrible thing that we're seeing this spike in rhetoric, because it will inevitably lead to more and more violence against every group. We're talking about anti-Semitism, but what starts with the Jews never ends with the Jews, and it's really, really important to fight this kind of hate together. So I actually think we need to start a lot earlier than the university level. And kids aren't born hating; they learn it somewhere. And whatever we can do in a school system, which is again an extension of the government. So I think the kind of enforcing the kind of policies I'm talking about, for example, like Tinker, really, really important, because it can save lives. And so I think you're right. Focusing on universities, that's a backstop. Title VI, for example, is not meant to be this sort of disinfect and cure-all class action way of dealing with a problem like anti-Semitism. It's meant to be when there's a severe and pervasive problem at a particular university where people are not being able to engage in an educational opportunity, we can fix that. But you're not going to solve the problem with a Title VI case. What you need are the enforcement of standards, again, like Tinker, that say, hey, this isn't appropriate here, and to teach kids not only that you can't do this, but why you shouldn't do this and why it's inappropriate. And I think that's really where we need to be focusing.
Yeah, great. So final question, because we're almost out of time. What do you think, you just alluded to what you think the solution is, but can you give us some real nuts and bolts ideas of what you think needs to happen by either government leaders, business leaders, university leaders? What should we be doing right now to confront the rise in anti-Semitism so that we can stop it now and 3 years from now, we're not looking at, you know, this times 3.
Sure. Well, in particular on campus, I think it's really important for colleges and universities to have someone in the DEI office who is specifically attuned to the different aspects of Jewish life on campus and the different ways that Jewish identity is reflected. It's a religion, but it's also a race and a culture and ethnicity and a national origin. It's all of those things. And oftentimes on university DEI levels, it's routed to the religious office and not the DEI office where it should belong. Taking it one step further to the sort of general counsel and presidential level of universities, I think that they should be enforcing the Tinker Standard to prevent material disruptions before they happen and not interfere with the rights of others. Taking it one step further to the legislative level, I think we should be adopting policies where, again, you know, you can't fight something that you can't define. And so the federal government, the State Department, the Department of Education, now 8 other federal agencies, they've all adopted sort of the International Holocaust Remembrance Alliance framework. And we should be encouraging that across the board. There's a couple of bills moving through Congress now to codify the executive order. I think that's a really important step. And I think that largely because the law also has an educational function. And so helping people learn, again, at a young age through DEI training, through diversity training, through anti-discrimination training, whatever it might be, what anti-Semitism is. It's important, you know, to borrow a phrase from Ibram X. Kendi, not just not to be anti-Semitic, but to learn how to be an anti-Semite.
Yeah, great. Well, we're out of time. I really appreciate you coming and making us a little more knowledgeable about how we can be addressing anti-Semitism and how we should be thinking about the First Amendment. Thank you so much, and I hope we can do this again sometime.
Thank you so much for having me. Really appreciate it.